Good morning. I'm not sure if we're supposed to wait for are we supposed to wait for a recording notification, or are we good to go, Chelsea? Good to go. Okay. Oh, there we go. Good morning, everybody. We appreciate you coming here for this Zoom oral argument. I know that neither of the attorneys requested oral arguments. So we appreciate you accommodating the court's questions today. We only have one case on our docket this morning for the November 20th docket of the Kansas Court of Appeals, and that's case number 127325, State of Kansas versus Robert Wayne. And counsel, is it Evel or Evel, like Evel Knievel?
It's pronounced evil, Your Honor.
Okay. Thank you. And let's go ahead and have you to state your appearances, and then let me know, Mr. Shire, if you'd like any time for rebuttal.
May it please the court, Sam Shire of the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant, Mr. Robert Evel. Your Honor, may I please reserve 3 minutes of rebuttal argument?
Yep. Sure.
May it please the court, the appellee State of Kansas appears by Stephen J. Overmeyer, an Assistant Solicitor General, present and ready for argument.
All right, thank you. I'll get my timer adjusted, and then Mr. Shire, you can go ahead. All right, we're ready. Thank you.
May it please the court, I'd like to begin with issue 1 of the brief, the prosecutorial error claim, and then move on to issue 2 to the extent time permits. If I'm not covering the topics that this court is most interested in hearing, please do redirect my argument. So I will preface my prosecutorial error argument by noting that this case was truly a credibility contest. The complaining witness recounted 2 incidents of alleged sexual abuse that happened in 2015. My client, Mr. Evel, emphatically denied those allegations of wrongdoing. This case doesn't implicate any forensic evidence like DNA. There are no corroborating eyewitness accounts, and there is nothing like a confession. To convict my client of offenses that carry presumptive lifetime prison sentences, the jury had to find that the complaining witness's accounts of abuse were so reliable that they in and of themselves amounted to proof beyond a reasonable doubt of the state's charges. And in my view, I believe that the state won this credibility contest at trial by resorting to prosecutorial error. This began at the very start of opening statement, when the prosecutor informed the jury, quote, "This case is pretty simple. It boils down to one thing. You will either believe the complaining witness or you won't believe her. At the end of trial, you will either believe the things she tells you that happened or you won't." By telling the jury in this case that this case boiled down to a determination of belief, the state greatly diluted its burden of proof.
But counsel, I mean, isn't that really just a way to frame the question? I mean, that was the ultimate question for the jury. They had to decide whether they were going to believe the victim or believe your client. I mean, you said this is a credibility contest, and there's no mention of reasonable doubt in that statement. Why isn't that statement just really framing that question for the jury?
Well, I think the problem here is that the prosecution is telling jurors that this case boils down to belief. So what that indicates to the jury is that its verdict turns on whether it believes the victim or not. And that is not really what this case boiled down to. Yes, this is a credibility contest, but the state doesn't win that contest simply by persuading the jurors to believe the complaining witness. The state has to believe the complaining witness beyond a reasonable doubt. In Mukes, and I believe in Supreme Court precedent as well, there is a distinction between mere belief and proof beyond a reasonable doubt. Mere belief it reflects an assessment of probability, that you think something is more likely than not the case. That's quite different than proof beyond a reasonable doubt.
But in the Mukes case, we had a statement that went on to talk about that burden. In the Mukes case, the prosecutor not only said, hey, if you believe the victim, you need to decide who you're going to believe, but they also said if you believe the victims, then the state has met the burden beyond a reasonable doubt. And we don't have the prosecutor here going beyond and making that type of statement, do we?
Well, I think you actually do later in the case. First of all, I would just note my belief again that by saying that this case boils down to belief, it's certainly intoning to the jury that its verdict turns on that belief finding. But later,
counsel, before we leave that, and I think I know we're going to go on the later, but before we leave this part, wouldn't any the jury instructions that each and every element needs to be proven by the state beyond a reasonable doubt have cured any problem with saying, hey, instead of saying this is a credibility issue, it depends whether you believe one witness or the other? That's basically what prosecution was saying, wasn't it?
well, Your Honor, I disagree. And
Well, what is credibility then? Tell me that. You started this whole thing saying, I'm going to summarize this case. This is a case about credibility. It sounds to me you did exactly what the prosecutor did. You just used the word credibility as saying the whole issue in credibility is, do you believe witness A or witness B? And of course, the jury was instructed to weigh the evidence and determine, do they believe witness A or witness B? So tell me why I'm wrong.
Well, Your Honor, I do believe that this is a credibility contest. The problem in this case is that finding that the complaining witness is credible is not in and of itself enough.
Right, and that's why we instruct the jury that they have to prove, the state has a burden to prove beyond a reasonable doubt each and every element of the crime charged. And that was done here, was it not?
Well, yes, Your Honor, that was done. The jury did receive an instruction to finding proof beyond a reasonable doubt. That's something that happens in every case. It's literally structural error if a court does not give that beyond a reasonable doubt. Of course,
and that's very important in a credibility case.
And Your Honor, I guess I would just move on to the later incident at this point, because I think that's also very important.
It seems like your biggest issue is when the prosecutor said she's going to be open and honest with you. Seems like that's probably the bigger question.
That's also very important, Your Honor, and that's vouching. So in my view, we don't just have this problem of the prosecutor diluting its burden of proof. It's also telling the jury that the complaining witness is going to be honest. So the prosecutor is putting its thumb on the scale basically by saying, we are vouching for this witness's credibility. But I also think really out of all the problematic arguments in this case, the most problematic happened at the very beginning of closing argument, where the prosecution tells jurors the complaining witness says that Robert Evel sexually abused her. Robert says he didn't do those things. So you either believe the complaining witness or you believe Robert. There's no such thing as we believe her, but a finding of not guilty is you, the jury, telling the complaining witness you don't believe her. This is the point where I think any ambiguity as to what the state is trying to convey to the jurors is dispelled. What the prosecutor is telling the jury is that if you return an acquittal, that means you do not believe the complaining witness, and that is not what an acquittal means. An acquittal means that the state hasn't proven its charges beyond a reasonable doubt. I believe that was extremely prejudicial, and it gives context to all the other many times in this case where the state is telling the jurors that this case boils down to a finding about whether you believe the complaining witness or not.
But you mentioned context, and isn't it important then to look at the context of the prosecutor's closing? I mean, he then repeatedly says, we believe her, but this child waited too long. Does that cause reasonable doubt? And repeatedly then the prosecutor brings in the concept of reasonable doubt. Does that not soften those comments or bring those within the realm of the prosecutor emphasizing its burden?
I believe not, because the problem in this case is the dilution of this burden of proof. The jury got the burden of proof instruction. What the state is doing with its arguments in this case is really downplaying that burden and saying, yeah, proof beyond a reasonable doubt, but if you believe her, that's enough. And that's really the fundamental error in this case. I believe that was extremely prejudicial, particularly coupled with the witness vouching that happened during opening statement. And in closing argument, the prosecutor also instructed jurors to, quote, completely ignore exculpatory evidence admitted on my client's behalf, and then apologize for the, quote, complete waste of time that jurors spent hearing that evidence. So when you take a big picture view of what happened in this case, in my view, what happened is that the prosecutor told jurors that it was good enough if they simply believed the victim, a complaining witness, that you could return a guilty verdict. It vouched for the complaining witness's credibility, and then it told jurors not even to consider the exculpatory evidence admitted in this case. When you put that all together, I think that this court is compelled to reverse unless the evidence in this case was truly overwhelming, which it was not. This is a credibility contest. And so I would respectfully ask this court to remand for a new and fair trial on the basis of prosecutorial error. I'll touch just very briefly on the second issue in the brief, unless this court has further questions. I
don't have any other questions on the prosecutorial error issue. Do either of you?
No.
I'll try and summarize issue 2 very quickly, because I think at its heart, it's really a pretty simple issue. In pretrial litigation, the parties decided that evidence of my client's alleged mistreatment of his daughter was inadmissible pursuant to KSA 6455. The court decided that another incident of alleged prior sexual misconduct would be admissible at trial. Those were the pretrial admissibility rulings. Now, at trial, the state admitted an exhibit that for the most part was admissible, but it included about 5 lines of statements that were inadmissible pursuant to the court's pretrial limine order.
And can I stop you there? I need to clarify. So that statement was admitted as evidence at the prior hearing, correct?
Yes, I believe.
That friend testified about her experience with your client, correct?
Yes,
But she did not testify at that hearing about the daughter. Is that correct?
That's correct, Your Honor. The daughter did testify, and the parties agreed that her testimony would be inadmissible because it implicated KSA 6455. And I know the state, in its brief, wants to argue now that that evidence actually was admissible. I think we're past that point because the parties agreed in the pretrial litigation that it was out. The state hasn't cited any reason for why this court should reconsider that issue for the first time on appeal.
And isn't it more than just an agreement? I mean, the state filed a modified motion where they conceded that that incident that SG testified to was not admissible, correct?
Yes, correct. Explicitly conceded that that was inadmissible.
And that's more than an agreement. We've got a specific admission in a filing and also representation to the court that we all agree that's not the incident she testified to support the character evidence wasn't admissible. I thought that the parties agreed that potentially the character testimony might come in if defendant opened the door. But
exactly, Your Honor. So basically what was decided is that the daughter could potentially testify as a rebuttal witness, but not in the state's case in chief.
And only to the character evidence, correct? There wasn't an agreement about this incident potentially coming in rebuttal, correct?
That's correct as well, Your Honor.
Okay.
And so that's the backdrop. The actual evidentiary error in this case is really, I think, pretty straightforward. Defense counsel, when this evidence came in at a trial, raised a 6455 objection. The state responded that it should come in because it wasn't hearsay, and then the district court ruled that the evidence could come in because it wasn't hearsay. And the problem with that is that 6455 evidence is inadmissible whether it's hearsay or not.
And my question about that colloquy at the bench conference is, you know, your predecessor raises a 455 objection, and then it kind of divulges into this hearsay conversation, and the court seems to rule on the issue as if it's a hearsay question. And I don't see a ruling there in the bench conference about the 455 objection. Is that fair?
That's fair. The court didn't return to the 6459. What I would interpret this as is that the court said that the 6455 evidence can come in because it's not hearsay.
Right. But later,
and,
when the statement is admitted at trial, when the state moves to admit it at trial, we've got a renewal of a 455 objection, and that's when the court says that the objection on 6455 is overruled pursuant to the court's earlier ruling. I mean, but that's the best we've got on a ruling on the 455 objection. Is that correct?
That's correct. And I think that contemporaneous objection really, I know the state has argued that to some extent this issue might be raised for the first time on appeal. I just fundamentally disagree with that contention, because the contemporaneous trial objection when this came in wasn't hearsay. It was KSA 6455, and the district court explicitly overruled the 6455 objection.
But back at the bench conference, you know, as an attorney, you're making an objection on one basis, and the court is clearly ruling on a different basis. Does it not behoove the attorney to say, actually, Your Honor, maybe you misunderstood me. I'm not objecting on the basis of hearsay. And redirect the court to the actual basis for the objection to get the ruling at that time? Isn't that the better practice?
I would have liked to have seen that done personally, Your Honor. But what happened in this case is sufficient to establish error, because we have the objection. The objection is not ambiguous. The objection is pretty clear. And then the court makes its ruling. If we had just stopped at that conference, I think maybe there might be something to work with from the state's perspective. But then when the evidence is actually admitted at trial, the renewed objection is KSA 6455. And so I think that is certainly enough to bring the issue before this court. And the district court's ruling is fundamentally erroneous in my view by admitting 6455 evidence on the ground that it's not hearsay.
But isn't it fair to say, when the court is talking about its prior 455 ruling, isn't that the ruling on the character testimony and not the specific incident? Because that's the ruling that when the court made its order, it specifically mentioned the character evidence. It didn't talk about this incident, correct?
Well, the state conceded that the incident wasn't admissible through 6455. So the district court's limine order basically just accepted that concession.
Right. And we don't have any below saying, hey, by the way, the state conceded that this evidence isn't admissible, and now they're trying to get it in. There's none of that conversation at trial.
During the bench conference, the defense counsel did allude to the pretrial litigation. And I think that should have keyed the district court into what the real dispute here was. And really, to the extent that anyone is guilty of setting the district court off track, I believe it's the prosecution. Because when the prosecution conceded that this evidence couldn't come in, they're the ones that are affirmatively trying to get it in. And then they are the ones telling the district court, this can go in because it's not hearsay. So could this have been handled better by all parties? I would say yes. But we do have the objection that preserves the issue to appeal. And really, if anyone is to be blamed for the misdirection of the district court's ruling in this case, I think it would be the prosecution. But I see that I've gone over time. If this court has any further questions, I would take those.
Yeah, I do. I don't have any other questions about the 455 issue for you. Do either of you, Judge Bruns or Judge Coble?
No.
No.
I have a question about the continuance issue. Just to clarify, what information was new that you didn't have that you claim you needed more time to investigate? Is it the late disclosure of the forensics interview about the accusations against the brother and Donnie?
That was lately disclosed evidence, Your Honor. Yes.
And so why are you claiming you didn't have that evidence before? Did you not have the forensics interview to hear the mom make those comments?
The mother made the comments about Donnie in a audio recording that the state provided to defense counsel the Friday before trial.
Okay, so that's the one you got late.
Yes. And I think
Okay.
defense counsel, this whole ball started rolling because there was a comment in the CAC interview that came out with regular discovery where this prior incident was briefly alluded to in a single sentence, I believe. And then
About the brother.
About the brother, yes. Not about Donnie, about the brother.
Right.
And that's what got the ball rolling. But I believe the prejudice here is that it's a late disclosure is better than no disclosure at all. I would concede that. I just don't feel that the disclosure was timely enough for defense counsel to make full and effective use of it because of all the investigatory leads that could be followed up based on the late disclosure of evidence.
Now, with respect to the brother, why didn't the admission cure the prejudice about the claims against the brother? Because there was an admission from the state that, she made this prior accusation. Why wasn't that enough with respect to the brother allegations?
Well, Your Honor, I think there's some problems with that allegation because at trial, it was disputed whether the false disclosure was ever actually made. The complaining witness testified essentially that an adult put words into her mouth and that she never actually said what was alleged. And so the issue isn't just that the abuse never happened. I think the stipulation was probably sufficient to get that point across to the jury. But it would have been ideal for the defense to better support the notion that the false disclosure was actually made, which is something that could have been done through further investigation. Possibly the brother would have been able to provide favorable testimony in that respect.
Okay, because you feel the victim's testimony maybe watered down the effectiveness of the admission?
Yes, Your Honor, because the complaining witness testified very explicitly that she never actually made the false disclosure.
And what about the accusations against Donnie? Did the admission address that at all?
No, Donnie never came in at trial at all. And it's not clear what exactly is going on with the Donnie situation. And the prejudice there is that defense counsel didn't have enough time to investigate that issue.
And that issue relates to a potential whole nother accusation against a completely different person.
Exactly, Your Honor. And if it had turned out that there were two incidences of alleged false disclosure, that would tend to establish a pattern at that point, and that would be extremely exculpatory.
Okay, I appreciate you clarifying. The record was a little confusing about those disclosures and what they related to in the admission. So thank you for that. I don't have any other questions on any other issues. Do either of you?
No.
No.
Okay. Did you want 30 seconds to wrap up, or do you want to just save your time for rebuttal?
I think I made my point, Your Honor. I'll save the rest of my argument for rebuttal.
Okay, thank you. I appreciate you accommodating my additional questions. All right, Mr. Obermeyer, I know that we went over, and so I'll make sure that you have plenty of time to address all the issues as well. As I mentioned at the outset, this is the case we've got on our docket today, so we've got a little time to get into the weeds here.
All right. I will briefly touch on the third issue and then go to issues 1 and 2 unless you want to redirect me. if you look at the discussion concerning the continuance, it covers about 35 or 6 pages of transcript. And I think the district court judge, Glenn Brown or Brown, I'm not sure how you pronounce it, but was very conscientious about providing the defendant the opportunity for a fair trial. And if the court looks at the comments made at sentencing, it was basically capsulized into all the evidence that the defendant wanted to have admitted that was discovered on the week before trial. It was all admitted and the defendant presented that. The defendant had an investigator, a retired or former FBI agent to investigate. And we haven't, nothing was presented about the red herring about Donnie or any of this other information. So I think that would be required to show prejudice and just not saying, oh, we didn't have a chance to investigate. I don't think that gets you to prejudice on the denial of a continuance, and that a reasonable person would agree with the district court's denial of the motion for continuance on issue 3. As far as issue number 1.
Counsel, I don't want to leave issue 3 just yet. Am I correct that the admission doesn't address Donnie at all? The admission that the state made to kind of cure the prejudice from the late disclosure only address the accusations against the brother. Is that correct?
I have not reviewed the police reports on that, so I don't know. I would just
the
rely
trial
on.
admission.
I'm sorry?
The trial admission?
It was mainly toward the brother, as I recall, at trial, and not to this other person. Yes.
So how did it address the potential that the victim had accused a different person and the prejudice against, the ability to go investigate that potential allegation?
Right. I don't recall that the victim did how that even came up with this other Donnie person.
Mother testified, or the mother told the police in one of the interviews, didn't she, that, oh, and all of what, by the way, she's also accused Donnie of this in the past. And I'm just trying to clarify the admission that the state made to try to cure the late disclosure. That only addressed the brother. Is that correct?
I think it did, yes, mainly address the brother.
Okay. And what's your response to the argument that, hey, we get to trial, and even though we have this admission, we've got this testimony from the victim who's really kind of backtracking on the whole thing. And so the defense doesn't have an opportunity to, kind of bolster the admission and counteract kind of that undercutting of it.
I don't think the investigator quit working on the Friday before trial. That information can be developed during the trial and follow up on this Donnie information. It was a 4-day trial. There's 2 attorneys representing the defendant. I think there's a way to follow up on this if there's some great evidence in that regard. And also with the motion for new trial or at the sentencing hearing, we've never heard how this would have panned out. So just to say, well, we don't know what we don't know, so he gets a new trial, I don't think that's prejudice. And I think when you look at the judge's discussion at the motion for continuance, that a reasonable person would agree with his ruling denying the motion for continuance.
Counsel, you keep referring to prejudice, but we're really under an abuse of discretion standard. And I recognize prejudice can go into whether it's abuse, but aren't we talking about a continuance is an abuse of discretion standard by the district court?
Yes, it is an abuse of discretion.
Okay.
And so I don't,
and maybe you don't know this, but what I think I heard counsel say was that Donnie wasn't even mentioned at trial.
I don't think that he was mentioned at trial.
Okay.
But I would
well, then he can clarify that if he was. I mean, I don't think this was even brought up. Could have asked her,
Right.
Did you make some other allegations? But he can clarify that.
Going to issue 1, I think defense counsel's argument is essentially that a prosecutor can't use the word believe in a closing argument. You can't say you should believe the witness. And I think the Mooks case dealt with the conflation of believing a mere belief in a witness being sufficient to prove a case beyond a reasonable doubt. And if you look at the context, starting with jury selection, where the prosecutor discusses, you have to be really convinced of the defendant's guilt, and the prosecutor asking a juror, can you find somebody guilty based upon a witness's testimony if you believe that beyond a reasonable doubt? So there was no effort to downplay the state's burden of proof in this case. I cited to the court State versus Thomas, which is the Supreme Court case where an attorney argued about believing a credibility battle and believing a witness, alleged victim versus another witness, and the Thomas case said that's what closing argument's about, credibility. Also, there's an unpublished Court of Appeals case, State versus Hill, that says the same thing, and the concern is the State versus Magallanes, I'm not sure how you pronounce it, but that you can't say, well, a mere belief that the defendant's guilty suffices, or if a juror personally believes a witness, that means beyond a reasonable doubt.
Counsel, what about the statement in closing that your counterpart mentioned today, where the state kind of personalized it and basically told the jury, you know, your verdict of not guilty is telling this victim here, you don't believe her. And that seems to kind of personalize the question. So whether that's appropriate.
Certainly, and I would direct the court to page 69 of that transcript in volume 18. My colleague left off at what happened after that. After the prosecutor says a finding of not guilty is you telling GMT you don't believe her, defense counsel objected that that's a mischaracterization of what the verdict would be. It was sustained by the court. So all of this evidence about all this discussion about believing or whatever, it's on defense counsel's radar. And there were two defense attorneys, by the way, sitting at a counsel table during the entirety of the state's closing argument. And we don't hear a peep about any of the other comments made by the state in closing argument, except for that one, which was objected to, that counsel did not mention that. So it's on defense counsel's radar if they think that there's a MOOCs violation or a Magallanes violation. The prosecutor didn't conflate a mere belief with beyond a reasonable doubt.
Was the counsel? I recognize I'm looking at the transcript. I recognize immediately defense counsel made an objection to the statement about a finding of not guilty as you, the jury, telling the victim you don't believe her. And what I have in front of us is sustained. Is that sufficient, or does there need to be some type of instruction to disregard that statement, or only if it's asked for? Because sometimes I know defense counsel doesn't ask for them a curative instruction because it's like waving a red flag and pointing to the evidence. So what's your position? It's just saying sustained, sufficient?
I think by sustaining that objection to the statement the prosecutor made, that the jury's not going to consider that that's what the verdict means.
But doesn't it also mean that the district court thought that was an erroneous statement?
Yes, and sustain, yes.
So it seems like there is at least some error. So assume with me that there's some error in the prosecutor's statements, even if it's just that one. What's your best argument as to the prejudice prong of Sherman?
My best argument as to the prejudice prong of Sherman is that that objection was sustained in looking at the jury was instructed concerning reasonable doubt that concerning statements of counsel are not evidence, and that was done at the beginning of voir dire, at the beginning of opening statements, at the beginning of closing arguments. This is a 4-day trial where the jury heard all the evidence, and We have expert testimony concerning how alleged victims of sex crime, child victims, how they might react. We have the 6455 evidence from THV with the similar evidence happening years before that, and that one comment which was sustained would not amount to a reversible error in this situation.
The open and honest comment. You know,
I'd like,
because you
sure.
mentioned, you know, we've got jury instructions that tell the jury the attorney's statements are intended to help you in understanding the evidence.
Right.
And that statement seems to tell the jury you need to understand the victim is honest.
Right. So the opening statement is a roadmap of what the defense or state's evidence is going to be. So if a prosecutor says the victim is going to be open and honest, could the prosecutor not say, have you been open and honest with us, Ms. Witness, concerning this? Yes, I have. So there would be evidence to support that. But in addition, at page 20 of the state's brief, I cite at least 15 times when the victim said, I'll be honest with you. Honestly, I don't think I'd remember. Honestly, no. Honestly, I couldn't tell you. There was evidence that the victim was honest with the jury. And this isn't a State versus Pabst situation where we're saying, well, the prosecutors, the state believes the defendant's guilty, so you have to find him guilty. Which, first off, I just find it hard to believe that juries are going to take as gospel everything the prosecutor says. This court never sees appeals from acquittals where what the prosecutor says isn't believed. Maybe Judge Bruns has.
No, I'm going to plead the Fifth Amendment.
Are there different rules for a statement by a prosecutor regarding whether the statement addresses whether the victim is being truthful or untruthful, or is the rule the same?
The rule, it's a two-way street on whether an attorney can give an opinion as to whether they believe a witness, and it's based on the rules of professional conduct. I forget which one. And there's a Court of Appeals case about 2000. Judge Marquardt wrote the opinion. It was the state's appeal on a question reserved where there had been an acquittal based on defense counsel making that type of argument. But it's a two-way street.
A prosecutor can point to evidence, either side can point to evidence that's consistent with the witness's story to bolster credibility. We can talk about their motivation to act. We can point to things as to why you should consider them to be honest. But why doesn't the prosecutor cross the line when they outright say a witness is going to be honest or going to not be honest?
I don't think that's conveying the personal opinion of the prosecutor in saying that. And again, if you ask the witness, are you being honest? There's evidence to support that assertion. And the victim repeatedly said that she was honestly believed this or was testifying to this or that. And so there was evidence to
witness at trial testifies that they're being honest. It's okay for the prosecutor to say, hey, look, that witness is honest. They told you they were. Because there's evidence to support that, and it's not the opinion of the attorney is the reason for that. And this is on the first day of a 4-day jury trial. I doubt any of the jurors go back and say, hey, did you hear that on the first day of trial? The prosecutor said, going to be open and honest. That's really towards the harmlessness of the error. Right. It relates to the harmlessness. It doesn't relate to whether it's an error. It's correct.
Right.
It seems like we could be past error because we know there was at least one. So I believe you agreed with me that when Judge Brown, well, Mark Brown pronounces his Brown or Braun. I'm not sure how this judge does, but it's when he sustained that objection, we know there's an error. So it seems like under Sherman, we move on directly to the prejudice prong.
Well, that was a sustained objection, though. I don't think that you.
Well, it was still error, whether it was sustained or not. It was sustained because it was erroneous. So the question is, was it unduly prejudicial? But the fact that it was sustained, I think, would certainly support your argument that it isn't prejudice, but it seems like was a misstatement, an error made by the prosecutor.
There was, and that was addressed at the time, and I don't recall if that's was briefed as one of the errors, but claimed errors. But I think the fact that it was sustained, the jury's not going to consider that statement. They were instructed,
which is why your argument would be it's not prejudicial because the judge sustained it. The jury's not going to consider it.
Right. Let's see, as I think I would ask also just to look at the context on the giving something little weight, little credit on the prior allegation. If I cite in the blue brief the entire context of the state's arguments on that at page 21, explaining why the jury concerning this 2013 evidence could give no consideration to it, and said it and left it to the jury that you could decide, how much credibility you want to give to this 2013 evidence with the victim, which the victim denied. So, for all those reasons, I think there was not reversible error on this issue. The prosecutor never minimized the reasonable doubt standard in opening or closing argument, and this is not a Magallanes violation. With regard to the second issue, unless the court has any other questions.
I don't on the first one.
6455 witness, her initials are THV, testified at the motion hearing concerning what had happened to her. Her written statement of January 1st, 2008 was admitted at that hearing. The judge took the exhibit with him after the hearing and then issued a ruling that the evidence concerning THV was admissible. The issue came up at trial when there's the objection at page 16 in volume 11, and the prosecutor answered at page 17, I think, that I don't think what's written in this statement, and it's on page 2 of the statement that ever since then, he would always rub my leg in a sexual way. Same with SG. He would touch, look, and make comments about us both sexually. He would always talk about how good we both looked and talk about our butts. And that was what the redaction was requested to be made. The court knows what its order is. The prosecutor did not think it violated the 6455 order. The court
did not violate the prosecutor's admission. After the hearing, we've got the state filing a concession that specifically says the daughter's testimony about the specific incident and comments made by the defendant to support her opinion about his character and reputation, which is the very incident that defense counsel is trying to redact, wasn't a specific incident that would constitute an act or offense under 6455G. Therefore, her testimony would not be admissible. Why is the state not bound by that concession?
The daughter did not testify at that hearing. The
daughter did testify at the 455 hearing.
I'm sorry, the daughter did not testify.
Incident that's mentioned in the statement. She testified about that very incident.
I'm not sure if it was that very incident, but
she testified about him touching her leg. On
Okay.
volume 5, page 22, she's saying, I recall when I was in high school, he placed his hand on my upper inner thigh, whatever. Later on, there's a bunch of questions about exactly where and the direction of his hand and how close he was. Isn't that the very incident that's the defense is trying to redact from THC's statement, basically that he was touching the daughter as well on her leg?
It may or may not be the same incident, Your Honor. I don't know. But what I do know
If
is
it's
that
not, why is it not similar enough to fall within your concession?
because the statement of THV was admitted at the 6455 motion. The judge took it with him before making the ruling, admitting the evidence. I think the prosecutor thought that states that exhibit was within the scope of the court's order and said that at the time of trial. But I think that was admissible. And the court knows what the court was ordering. The court looked at this statement. It read the part that defense counsel says is offensive and did not say that, yeah, I didn't intend for that to come in, so I'm going to redact it. The court did not do
The
that.
court's ruling on the 455 evidence before trial only allows the testimony of the friend to come in. It doesn't allow her statement to come in. And we also have a concession from you filed before the ruling. And so the court doesn't need to talk about the incident with the incidents the daughter talked about because you've already conceded they're not admissible. So why would the court need to address that?
Well, again, I think because the court had reviewed that statement at the 6455 hearing, and
But isn't there a difference in saying her testimony is admissible? Because she didn't testify. The friend did not testify about the incident with the daughter, did she?
no, she did not.
And so the court only allowed her testimony to be admitted. It didn't say her statement could also be admitted, correct?
Well, I think that kind of just goes with the territory. If that came in at the motion hearing, that's going to come in at trial. And it did come in at trial. They did object to that part that they wanted redacted or not. But I don't think that if the district court had a problem with that part coming in, the court would have redacted that. So I mean, I think it's just as far as clarifying what was the evidence that was to be admitted under the order. And I don't think that the court did not think it violated the order. And I also, there were at least 2 other occasions during trial where that reference came in on cross-examination of THV. That came in without objection. And then defendant was cross-examined about that as well. So it's kind of part of the
After the colloquy, after the bench conference, and after the objection to the statement.
it probably was.
Okay, and so when the statement, or when the state moved to admit the statement, defense renewed their 455 objection, and the court responded by saying the objection on 6455 is overruled. So why is that not enough to preserve the issue for appeal?
If the issue is preserved for appeal, the other instances where that evidence came in is more of a harmless error argument if you think that shouldn't have come in. But I again think the judge could have excluded that if he thought it violated 6455D and didn't. And I don't recall, and defendant argues in his brief that, well, this isn't aggravated indecent liberties with a child because she's over 16. That wasn't discussed at trial or presented to the court. And but certainly as to the 16-year-old THV, it was the sexual battery that was admitted. So that we have the jury hearing this. So how is it going to be prejudicial that as to SG that's the jury heard that, so that makes a difference in the outcome.
Didn't the state argue, or I'm sorry, didn't the defense argue it makes a difference because it's his daughter, and that's more inflammatory than someone he's not related to?
That might be in the brief. I don't recall that being in trial. They're both sexual batteries. And the issue about the state raising something for the first time on appeal in the reply brief, I think that line of cases is based on Supreme Court Rule 6.02 A. It deals with the content of the appellant's brief. If an issue isn't raised, the appellant has to explain why. But if I'm trying to defend the trial court's action as the appellee, I don't think I'm barred from, oh, you should have argued that way back in the trial court, that you should have predicted what was going to be argued when the case went up on appeal. So I think it's a sexual battery as to the daughter and as to THV. The judge read that language before he denied the motion to redact. The prosecutor thought that exhibit, which came in at the 455 motion, would be part of the evidence. And that's my argument on that. I think that covers most of what I wanted to argue. On the rest of the issues, I rely on the brief.
I don't have any other questions. Do either of you?
No.
No.
Okay, thank you. And thank you for your patience with all the court's questions.
Sure, thank you.
All right, Mr. Shower, I believe, did you say you wanted 3 minutes?
3 minutes, Your Honor. I'll just start off with harmless error. And I think what's important to note here is that when the state is arguing harmless error, I think what their argument all boils down to is that a jury would have found the complaining witness to be credible even if these trial errors hadn't have happened. And I know the state isn't conceding trial error, but once you get to trial error, the state is saying none of those would have affected the jury's assessment of witness credibility. And that really puts this court in a difficult position because this court isn't supposed to be making witness credibility finding itself. And I don't think that this court can say a jury would have found this witness so inevitably credible that it would have returned the same verdict even had these trial errors not occurred. So I think just given the way trial evidence came in this case, it's very, very difficult to make a finding of harmless error. And I don't think that the state has demonstrated harmless error in this case. I don't believe that my client received a fair trial, and I would respectfully ask this court to grant a new trial on the state's charges.
Could you clarify for me, you heard me ask Mr. Overmeyer, this whole situation of Donnie, I think it is, was Donnie ever mentioned in trial, even in a sidebar to the court, other than just the arguments that were made to try to continue the trial?
So the continuance request was taken up during trial. So Donnie was addressed at the sidebar bench conferences. In terms of trial evidence, Donnie was not mentioned.
And no proffer was made or anything like that?
Well, other than what's stated in the joint exhibits.
Which is that there could be somebody else out there, but it didn't come in. So I'm not sure how that one really prejudiced your client.
So the proffer, Your Honor, from the sidebar is that the prejudice is that defense counsel didn't have time to investigate whether there was another incident involving Donnie. It's the prejudice.
Do we know who Donnie was? Did you know who Donnie was? Well, not you, but your predecessors and their investigator. Did they know who Donnie was?
That's less than clear, Your Honor. I know at one point the judge during a bench conference stated that he knew who Donnie was, which is odd to me. Defense counsel never stated that they knew who Donnie was. And one thing that I do want to point out in addition, the investigator that my colleague refers to, I do not believe was working in conjunction with defense counsel. This was not an investigator retained by bids. This was an investigator that my client independently hired. So I don't believe that there was necessarily collaboration there. But again, the prejudice is that we have this newly discovered evidence. It begs for investigation, and defense counsel obviously could not conduct that investigation in the middle of trial.
Okay, and then just clarify a couple things for me about the 455D evidence slash hearsay objection commingled into each other. Mr. Overmeyer said that this evidence came in anyway without objection. Is that accurate?
After the evidence came in, the prosecution emphasized it during its direct examination of THV and the cross-examination of my client.
Was there an objection or a request for a standing objection?
There was not a renewed objection. However, had that exhibit been excluded from evidence, the state wouldn't have had a basis for asking those questions.
Well, I'm not sure how we know that, because I'm looking at this, it's kind of almost like an order in limine, this pretrial journal entry. And it says the state will be permitted to present the testimony of THV in its case in chief. The state will, however, be barred from introducing character evidence concerning the defendant unless and until the court finds outside of the presence of jury that the defendant has opened the door for said evidence to be admissible. It does not seem to specifically cover this statement. It seems like the statement was addressed at trial, even though it was certainly considered in the 455 hearing. Is that accurate?
So it was considered at the 455 hearing, and at the end of the hearing, the state filed a motion/concession saying we can't get that evidence in through 6455, which is why it's not addressed in the district court's limine order. I guess what I hear the state arguing today is they're trying to draw a fine distinction between getting that evidence in through the testimony of a witness versus getting it in through a written statement. And I fail to see how that is a distinction of any consequence.
Well, usually if there's something in a written statement and that witness testifies, you can get it through the oral testimony. As a matter of fact, that probably would be the better way to do it. What was preventing her from testifying, just testifying about these things? Let's assume there wasn't any written statement.
Could you clarify, Your Honor?
What if she would have said the same things in her testimony, in her oral testimony, that she had said in her written statement, and they didn't even try to introduce the written statement?
And you're referring to THV, Your Honor?
Yes, THV.
Okay. I believe if she had attempted to do that through her oral testimony, that's when the trial objection would have been lodged at that point. It would have most certainly been better practice for defense counsel to renew the trial objections when the state touched on this again, emphasized it during the direct examination and cross-examination of other witnesses. But that was after in time the district court had already ruled that this evidence was admissible. I don't believe that evidence would have come in had the district court initially ruled that the evidence was inadmissible.
But does that relieve your obligation to make a contemporaneous, either make a contemporaneous objection, or as soon as he ruled that it's admissible, ask the trial court judge, Your Honor, can we have a standing objection so I don't have to keep getting up and objecting every time they mention it? I mean, I'm old, but that was done all the time in trials when I was a district court judge. I'd either give them a standing objection or they'd raise a contemporaneous objection. They wouldn't just let stuff in without objection.
Well, Your Honor, it most certainly would have been best practice to ask for the continuing objection.
Well, it's not just best practice. Isn't that the law, that you have to make a contemporaneous objection?
Well, as to that later evidence being admitted, what we do have for certain is a contemporaneous objection. We have a contemporaneous objection that was made at trial when that written statement came in.
No, I'm not doubting that. I'm saying, and I don't think even Mr. Overmeyer is doubting that. What he's saying is, and it has some appeal to me, that's why I'm giving you the opportunity to respond, is that just because a judge makes a mistake and admits something, at one point in the trial does not relieve counsel's obligation to continue to object or to ask for a standing objection. Seems to me that at that point, when you let it in anyway, then it ends up becoming harmless.
Well, Your Honor, my best response to that, and what I hear my colleague making as well, is a harmless error argument, that even though it shouldn't have come in here, it's harmless because it came in here and here.
Because it
My
came in
response to
anyway.
that, my response to that would be, number one, we still have error because we have a contemporaneous objection that was ruled upon. I would submit erroneously. So error happens at that point. As to harmlessness, I do believe that there certainly would have been an objection at a later point had the state attempted to get this in through direct testimony. And in any event, the state wouldn't have had sort of the launching pad to ask that question had the district court not let that written statement into evidence. So I don't think that that subsequent testimony would have come in as it did, but for the district court's initial erroneous ruling. That's my best answer to this court's
No,
question.
I appreciate it. It's a difficult question because I mean it does happen in real life, and as we all know, trials are fluid.
Unless this court has any further arguments, I'm concluded with rebuttal at this
Hopefully,
time.
we're just asking questions and not making arguments.
Oh,
But
excuse me, Your
sometimes
Honor,
it
I
may
didn't-
appear our questions are argumentative. But we don't intend that.
Slip of the tongue, Your Honor.
I don't have any other questions. Do either of you?
No.
No, very good arguments by
Thank
both
you.
counsel.
Yes, thank you both. That will conclude our docket and we will issue an opinion timely and in due course.